Tonight, we have an attorney general taking an unprecedented position. Attorney General Barr is saying that no staff attorneys on any committees can ever question him. Of course, Congress has been doing it that way for decades, for as long as I've been alive. Some of the most famous questioning in congressional hearings has been done by staff attorneys. And so William Barr has issued kind of a threat, and we don't know if he's going to show up at the House Judiciary Committee hearing where they want to use some staff attorneys to ask questions instead of just the members of the committee. The Senate Judiciary Committee is run by Republican Lindsey Graham, and they're going to do everything exactly the way William Barr wants them to do it. So there won't be any tension for William Barr in the Senate Judiciary Committee hearing on Wednesday. But on Thursday, he's saying he just might not show up for the House hearing. And so there's a statement tonight from the Justice Department saying the Attorney General agreed to appear before Congress. Therefore, members of Congress should be the ones doing the questioning. He remains happy. Do you believe that? Happy? He remains happy to engage with members on their questions regarding the Mueller report. House Judiciary Committee Chairman Jerry Nadler explained the need for committee lawyers to question the Attorney General.
We've seen any number of instances under the 5-minute rule where a witness will filibuster for 4.5 minutes and give a non-responsive answer in the last half minute, and you can't follow up. If the Attorney General is afraid to subject himself to questions where you can follow up, well, that may indicate lack of confidence in his own position. It's not up to the Attorney General to tell the committee how to conduct its business, or we will decide what the most effective way of asking questions are, and that's what our decision is.
Chairman Nadler said that Attorney General Barr could be subpoenaed if he refuses to testify this week.
What will happen if he doesn't show up?
We've told him we expect him to show up on Thursday, and we're going to conduct the inquiry as we've said we would. If he doesn't show up on Thursday, we'll have to go to subpoenas.
Chairman Nadler said this tonight when he was asked about whether William Barr's objections to testifying could change the committee's position on impeachment.
If the administration continues to stonewall, doesn't let Barr come, doesn't give you the report, et cetera, that you want, does this help build the case towards starting impeachment proceedings?
It certainly builds the case that the administration and the president is engaged in wholesale obstruction of Congress, completely extra-constitutional, trying to make the presidency not responsive to Congress, trying to make the presidency into a monarchy. It is absolutely unacceptable, and we'll take whatever action we have to do to deal with it.
Including impeachment proceedings?
That remains to be seen.
The Washington Post is reporting tonight frustration among House Democratic investigators is intensifying after President Trump's refusal to cooperate with congressional inquiries, leading some to privately question whether they should try to pressure Speaker Nancy Pelosi into launching impeachment proceedings. The chairman and members of the 6 panels investigating the president are increasingly angered by the White House's unwillingness to comply as they carry out their oversight role, according to several House Democratic officials who spoke on the condition of anonymity to discuss the matter freely. House Speaker Nancy Pelosi said this today about the Attorney General's upcoming testimony.
What's your message to Attorney General Barr?
Respect the Constitution. Honor your oath of office. Honor the
And let's just take a look back to some of the most important questioning and most memorable questioning, stuff that I can remember from when I was in college. During the Watergate hearings, there were staff attorneys for both parties in the hearings offering the questioning. Fred Thompson became a big political star. Republican Fred Thompson, who was the Republican counsel to the committee, became a big political star as a result of his starring role in the hearings asking questions. That enabled him to mount a Senate campaign later in his career. Let's watch staff attorney Fred Thompson, Republican staff attorney Fred Thompson, in the Watergate hearings.
So you were employed on January 21st, 1969, and continue to be employed until March 14 of this year. Is that correct?
That's correct.
Mr. Butterfield, are you aware of the installation of any listening devices in the Oval Office of the President?
I was aware of listening devices. Yes, sir.
Maybe the most important question asked in the hearing, one of the most, certainly. Let's watch Sam Dash. Sam Dash was the attorney, the counsel on the Democratic side of the committee. Let's watch him at work.
Now, with regard to the telephone taps, they were operated, were they not, by as soon as the president, who may have used his telephone, lifted up his telephone and engaged in a conversation or received a conversation on his president's phone, the recording device began to record the telephone conversation.
That's my understanding, Mr. Dash, but I lack all of the technical knowledge of the telephone recording device.
Leading off our discussion tonight, a member of the committee that has jurisdiction over impeachment, Democratic Congressman Jamie Raskin of Maryland. He's a member of the House Judiciary Committee, and who might be questioning William Barr this week. He's also a member of the House Oversight Committee. Also joining us, Yoni Applebaum, senior editor at The Atlantic. He wrote the cover story making the case for impeaching President Trump before the Mueller report was completed. And Julian Epstein is with us. He is a former Democratic chief counsel to the House Judiciary Committee. No one knows the procedures of the committee better than Julian Epstein. Congressman Raskin, let me start with you. I can remember Fred Thompson. I can remember Sam Dash from the Watergate Committee hearings better than I can remember any member who was actually also on the panels asking questions. And we remember specifically what their questions are. The Attorney General has no standing that I'm aware of to object to the processes of the committee. Does the Attorney General know something that I don't know about the House Judiciary Committee?
Well, he doesn't run the House Judiciary Committee. He doesn't run Congress. And we're not going to allow him to micromanage the format of our questioning. And as I think you quoted a little excerpt from an interview with Chairman Nadler, the committee feels very strongly about the witnesses that have been coming earlier from the administration and just filibustering us. I remember when Attorney General Whitaker came in and he would have these huge windups for 45 seconds, 60 seconds praising the question. And it was such a brilliant question. So finally people said, don't praise my question. I don't need to be thanked, just answer my question. But obviously they're being taught to filibuster. So what we thought we would do is each member would have 5 minutes to question, and then there would be 30 minutes where the Republicans would be able to question and 30 minutes where the Democrats would be able to question. And as you're pointing out, there's great tradition and precedent for that. And it's up to us. And suddenly we have the Attorney General trying to dictate to us how we're going to run our committee. And I know Chairman Nadler and the members are not going to accept that.
Julian Epstein, knowing the rules of the committee the way you do, what's going to happen here?
Well, I think there's a standoff right now, and the committee certainly has the rules under the House rules to be able to have staff ask questions. It's exactly what we did during the 1998 hearings with Ken Starr, where we had our investigators ask questions. In your setup piece, obviously, you talked about all the other precedents, Iran-Contra, Watergate, so on. I think some of this discussion, there's no question about precedent. There's no question about staff asking Senate-confirmed cabinet officials to be able to testify. That's well established in precedent. And I think some of this conversation misses the forest for the trees. This is really the opening shot in a longer-term game that both the Justice Department and the House Judiciary Committee are playing. The Justice Department has a theory on the case. Their theory on the case is that we can ignore all the norms and the precedents and just kind of thumb our nose at the committee and say, see us in court, and we can tie this thing up in court for months, if not years. And in the meantime, House Judiciary Committee, you've got about as much evidence as you're probably going to get. If you think the president obstructed justice and violated the law, call the question on impeachment. I dare you to. That's Barr's theory on the case. The Judiciary Committee's theory on the case is, you know what, we've probably got a better legal argument to get access, not just to be able to conduct hearings the way we want to, but there's other issues here that are even bigger issues. I don't think Barr testifying on Thursday is going to advance that knowledge that much, because I think he knows how to dance around the questions. But the bigger issues here are whether the Judiciary Committee will be able to get the redacted portions of the Barr report and will be able to get access to witnesses and the underlying material. And the Judiciary Committee's theory here is that we've got a stronger case in court ultimately ultimately. And if you want to take us to court and tie us up in court for the next, several months or even year, guess what? We're going to Benghazi you. And we're going to Benghazi you with a whole bunch of hearings because the Barr report, the Mueller report is a rich tapestry of a foreign government attack on the United States that the Trump administration and the Trump candidacy cheered and benefited from. So we'll have those hearings, and that's the tableau that's being set right here. And I wouldn't bet against. I've worked with Jerry Nadler for years during the Clinton impeachment. I've known Jamie Raskin for decades. I wouldn't bet against these guys in that fight. These guys know what they're doing. They're methodical. They know how to set up hearings, and this is a long-term game that I think the Trump White House is going to end up losing. They're going to carry this issue rather than putting this issue away in the next 6 months. They're going to carry this issue into the election, and it's going to cost them.
Yoni Applebaum, when your Atlantic cover story came out about impeachment, it was arrested everyone's attention. We talked about it here on this program for at least a week or so. It created its own sort of surge of interest in impeachment. And then that died down rather dramatically. And here it is revived again with the release of the redacted version of the Mueller report. And now you see Chairman Nadler, every other question he's asked now somehow includes the word impeachment in that question. Will this thing that the Attorney General is doing provoke impeachment? What is your sense of where we are in this curve of history that might or might not lead to impeachment proceedings?
Well, it's a great question. In many ways, I think the Mueller report, or at least that portion of it that we were allowed to see, amounts to an impeachment referral. He is reminding all of us about the constitutional system under which we operate, in which a sitting president under Department of Justice guidance can't be charged with a crime. That process, and this is one thing that Robert Mueller and Attorney General Barr and Brett Kavanaugh actually all agree on, that impeachment is the process for holding a sitting president to account for potential criminal misconduct. And the Mueller report has kicked the ball back into Congress's court, which is really where it's been all along. And so that is, I think, why this conversation keeps coming back around to impeachment. Ultimately, if the things that members of Congress have repeatedly charged the president with having done are true, if he's done them, that is the constitutional remedy for those charges.
Congressman Raskin, Julian just alluded to something that I've been wondering myself, and that is the point of William Barr testifying to the House Judiciary Committee. Now that we have seen him testify, now that we saw him in his confirmation hearing, now that we saw him go through another round of testifying to Congress, it seems as though he is prepared to deal with, evade, not respond reasonably to any kinds of questions you can come up to, if that's what he wants to do. He's also capable of direct and clear answers. We've seen him do that also. He seems to have the full range of ability to respond in a way that serves him and his position and President Trump. And so that raises the question of, how important is this hearing with William Barr anyway? Because Julian and I both have a feeling we know how it's going to go.
Yeah.
Well, he's clearly not the most important witness for us. I mean, we're very eager to hear from Don McGahn, the White House counsel who was told to get Special Counsel Mueller fired and effectively refused to do it, threatening his resignation, or tendering his resignation, as I understand it. We want to hear from Mueller himself. There are definitely more important witnesses than the Attorney General. I think members are eager to question him about the quite unprecedented propaganda rollout of the Barr report on the Mueller report, and some of the perverse legal reasoning that he offered us. But I think that probably goes more to just deconstructing the different theories he's advanced than it goes to getting to the underlying facts of the case. So if he really insists on pressing his point, I, for one, would not consider it a tragedy if we got right to the people who are going to tell us the truth about what took place.
Go ahead,
I was going to say, I mean, that is the advice that I have given to the staff, and Jamie is as smart a constitutional expert as any in the country on this, but I would not take Barr up there alone and let him spin this under the 5-minute rule in the way he's done it. I can just imagine what his answers are going to be, particularly for the 4 most poignant areas of questioning on the obstruction, where Mueller said he thought there was substantial evidence of obstruction. I wouldn't give him that tableau. I wouldn't give him that stage. I would say that's part of a systematic process that we're going to undertake, but we want access to Mueller, we want access to McGahn, we want access to the 6E material, we want access to the other underlying redacted material, and there's a whole slew of other witnesses that we want to be able to get access to. And that's part of the larger discussion here. But just having Barr alone, I'm not sure how much really advances the discussion here.
Yeah, and I think Julian makes an insightful point. It would be interesting to see Barr cross-examined on his representation of what's in the Mueller report with what is actually in the Mueller report, like when he said that, repeated the Trump's favorite phrase, no collusion, and then juxtaposed that against Mueller's statement that he wasn't dealing with the question of collusion, he was dealing with the question of criminal conspiracy. But there are a number of cases like that where it was very clear that the Attorney General was engaged in spin and being a publicist for the president rather than acting as Attorney General of the United States.
Yoni Applebaum, in our recent history of impeachment proceedings, it has not involved a first-term president. It's always been a second-term president not running for re-election. What do you see as that dynamic of it being a first-term president in the middle right now of a presidential re-election campaign? How do you see that affecting the question of impeachment?
It takes me back to Andrew Johnson, who was in his first term, a partial term, and was a lot closer to his reelection when the House finally pulled the trigger on impeachment against him. Impeachment is a separate process from electoral processes. It's a way to weigh a president's fitness for office and whether or not he's committed high crimes and misdemeanors. An election can't really resolve that for you. If a president has done that and gets a majority of voters to back him, that is perilous in its own right. And that's why there's a separate and alternate process. You can watch Attorney General Barr here try to provoke a confrontation with Congress, try to stonewall, as many administration officials are stonewalling, any kind of cooperation. And it's hard not to conclude that they're trying to run out the clock and to push this into 2020. And that's a real challenge for the House.
That's exactly right. Well, it is a challenge for the House, Lawrence, and it is a challenge. The Stonewall issue is a challenge. Enforcing subpoenas are a challenge. But the reason I think that Barr's strategy here of running the clock and trying to stonewall is probably going to be a mistake, because there are lots of witnesses that they can't stop. For example, you talked about Deutsche Bank being subpoenaed by the New York Attorney General. House Judiciary Committee can do that as they can for lots of other witnesses. They are breathing life into this issue that they're trying to put away.
Okay, we're going to have to leave it there for this break. Julian Epstein, Yoni Applebaum, and Congressman Jamie Raskin, thank you all very much for starting us off tonight. Thanks for checking out our YouTube channel. Subscribe by clicking on the button below for more from The Last Word and the rest of MSNBC.